Welcome to our sixth and final election forum for 2020. This evening we'll focus on the state Supreme Court and on two pocketbook ballot issues in the November 3rd general election. My name is Neil McReynolds, chair of the Election Forums Committee. To help you prepare to vote in the important November election, the Election Forums Committee will present this evening the four finalists for two contested positions on the Washington State Supreme Court. In addition, this evening, we'll have presentations on two of the ballot issues on which we'll be voting in the November election. One is King County's $1.7 billion bond issue for renovation and construction at Harborview Medical Center, and the other is the City of Seattle's proposal for a transit tax increase. We know how important it is for those of us who are here at Horizon House to know what we are voting on each election. That is why we're conducting 6 candidate forums as well as presenting ballot issues this year. We'll be voting on 16 ballot issues in November, but we have time to do our presentations on only 4 of them. As a result, our committee has produced a written summary of the other 12 ballot issues, and we placed the summary in each of your copies 10 days ago. Additional copies of the ballot issues summary can be obtained at the front desk. And now for tonight's program, featuring the 4 candidates for the 2 contested positions of the state Supreme Court, an area of state government that we haven't addressed before in our candidate forums. As we've done for the 6 other statewide elected offices we have presented in the earlier forums this year, we would like to offer a brief tutorial on the Supreme Court and its role and responsibilities. The Supreme Court is the highest court in the judiciary of the state. It's composed of the Chief Justice and 8 justices. The mission of the court is to uphold the state constitution, and when called upon through cases to interpret laws passed by the legislature and enforced by the executive branches of government. 2 notable cases in recent years illustrate the important role the Supreme Court plays in the state. One was the 2012 McCleary decision, where the court ruled that the state of Washington failed to meet its constitutional duty to adequately fund education. The other was the 2019 Gregory decision, where the court unanimously decided the death penalty in Washington violated the state constitution as applied. The state Supreme Court, as described by many, plays a key role in the checks and balances systems of state government. The only required qualification for justices is that they are admitted to practice law in the state of Washington. If there is an opening on the court, the governor appoints a person to fill the vacancy who will serve until the next election. We have examples of gubernatorial appointees in the 2 races we're featuring this evening. With that background, let me introduce the moderator for this evening's forum with the Supreme Court candidates, Chuck Ruth, a resident and a former clerk for the state Supreme Court in his early legal career. Chuck.
Chuck, unmute yourself.
Thanks, Neil. And now for tonight's program. Before introducing the 4 candidates for Supreme Court, let me offer a few words about the role and what those people do. The Supreme Court in Washington is the highest court in the state. It not only issues decisions in individual cases, but oversees the lower courts, approves state court rules, directs the work of commissions and committees. And unlike all of the other candidates we have heard about, the candidates for Supreme Court are bound to obey the code of judicial conduct. For example, they are not to speak about any issue that is likely to come before the Supreme Court. They are not to directly accept any campaign contributions. A judge or a candidate for judicial office shall not engage in political or campaign activity that is inconsistent with the independence and integrity, impartiality of the judiciary. There are two people running for position 3 of the Supreme Court, which is a 6-year term. These are Justice Raquel Montoya-Lewis, who was appointed to the Supreme Court by the governor in December 2019, and Judge Dave Larson, who is a judge from Federal Way. There are two people running for position 6 of the Supreme Court, which is a 2-year term. They are Justice Helen Whitener, who was appointed by the Supreme Court by the governor in April 2020, and Dr. Richard S. Serns. Let me now say, what special qualifications and/or prior experience do you possess? To Judge Larson, what special qualifications and prior experience do you possess that makes you the best candidate for the office of Supreme Court Justice?
Well, thank you for the opportunity to be here. It's greatly appreciated. It's hard to vote for judges, and this will make it a lot easier, I hope, for folks. I was a trial lawyer for 23 years. I tried cases in state and federal court. Latter part of my career, I tried complex civil litigation. I was handling cases where you'd need 25 chairs in the room for lawyers. I was national counsel. I was the chair of a department at a large law firm that dealt with all the discovery for 15,000 asbestos lawsuits nationwide. I worked on aerospace litigation. The last case I worked on before I became a judge was damage to the King and Queen of Thailand's brand new 737. I went to traffic and misdemeanors at a municipal court. I was president of the Federal Way School Board, and our court was in trouble. It was very controversial. It was in the paper a lot, so I volunteered to go over and settle that court down. I've been there 12 years. It's been one of the most enriching experiences of my life, but frustrating at the same time. The thing is that sometimes when it comes to the trial courts, we're left alone, and there's a number of things out there that need to be addressed, including the battle we have with addiction, mental illness, and homelessness. It's no longer a local issue, it's a regional issue. I'm running because I want to be a leader on the Supreme Court. I want the Supreme Court to take more of a leadership role. We have a Minority and Justice Commission, a Gender and Justice Commission. I'd like to see us have a Behavioral Health Commission, so we can bring courts together, attack this in a regional way, regional coordinated way with partners outside the judiciary, so we can do those things. And I have very unique training, and in terms of managing a court now for 11 years, I understand what goes into managing a trial court. I understand the decisions. I've signed both sides of a paycheck. I've had my own firm. I've been in-house counsel. I've been with a large firm. And I have the perspective that I think is needed as a justice to be able to rule on cases, to breathe life into them for the people that actually have to utilize them in their day-to-day activities, whether lawyers, judges, or participants. And I'll end now, but we'll recircle back with some of the other issues. So thank you.
And now, Justice Montoya-Lewis.
Thank you, and I appreciate the opportunity to speak to all of you and wish all of you a happy Indigenous Peoples Day. As the first Native American on the Washington State Supreme Court, you take great pride in my unique qualifications to serve as a justice, and I look forward to serving for many years. I've been a trial court judge for 20 years. For the first 15 years of my career as a judge, I worked for tribal courts in Washington and in other parts of the country. And for the last 5 years, I served on the Superior Court for Whatcom County in Bellingham. I have done cases from the most minor of cases like traffic citations to the most serious cases like murder trials. And I have presided over hundreds of jury trials and seen thousands of cases as a judge in the course of my 20-year judicial career. In addition to that, I've been a professor. I was a tenured professor at Western Washington University, where I taught courses that were law-related courses. I taught legal writing. and I was also a professor at the University of New Mexico School of Law. Over the course of my career, particularly in the last 3 years of my Superior Court work, I was the therapeutic adult felony drug court presiding judge. I have started drug courts, I've written grants for drug courts, and then continued those drug courts in tribal court. When I moved into Superior Court, I presided over felony drug court. And I've seen the extraordinary change that therapeutic courts can do. I am a national leader on racial inequity and a national expert in training judges on racial inequity, implicit bias, and decision-making, as well as best practices in juvenile justice and domestic violence. And I look forward to talking to you further this evening. Thank you.
Thank you. And next question. What do you consider to be the 3 most important attributes of a good judge? And Justice Montoya-Lewis.
Well, I think the 3 most important aspects of being a good judge are, number 1, being a good listener, someone who is curious and can listen carefully to what people's stories are and recognize that they are in the courtroom often as a result of the worst day of their lives. Related to that is to be a judge that has compassion and someone who can take themselves out of who they are and imagine what it's like to be someone else. And from that perspective, make decisions. The third thing is to be able to be a decision maker and to be willing to follow the law, even when that law conflicts with what your personal views are. People are in your courtroom because they have been unable to come to a solution themselves. And so it's our job as judges to ensure that we provide those solutions when people need them.
And now to Judge Larson. Judge Larson, you need to unmute.
I wish I could disagree with Justice Montoya-Lewis, but she was pretty excellent on that description of what a judge needs to do. The other thing I'd add, though, is that we have to recognize our role in society being a peacekeeper. We have to keep society moving forward. We have to be somebody that, my motto is no repeat customers, or I run a repair shop, not a junkyard, as a trial court judge, because our system should help people have better lives. And I think that patience is a significant condition or a significant trait we need to have. We need to also, as Justice Montoya-Lewis indicated, understand that public trust and confidence comes from our ability to apply the law the way it's written and then not to impose our own views. The test for a judge is not what their personal opinion is, it's their ability to overcome it. And that is significant in whatever level of court you're in. Thank you.
And the next question to Judge Larson. The Washington Supreme Court recently issued a letter signed by all justices acknowledging that racism has infected proceedings and committing to address issues systematically. Are you familiar with the letter? What is your opinion of the letter? And how would that affect your actions on the bench?
Well, yes, I'm familiar with the letter. I think that this is one of the issues that I'm running on, is that for decades we've been looking through the wrong lenses. The letter, in large part, for the people we see in court, because I realized that the Black community in Federal Way had trust and confidence in me. I didn't realize how much until after the George Floyd incident. The letters like that, in a large part, are seen as symbolic, though. They want to see real action. They want to see some real change. And I've been working in, the reason they have so much trust and confidence is because of how I've been handling cases for years, called the magic, dignity, and respect. But it's about doing now. It's not about writing letters and everything. We actually have to do something. And some of the things are very simple, just in terms of changing the attitude and approach we have to justice. The idea that dignity and respect piece, that's so important, because Blacks especially It's not that we cause racism in the system, but how we treat people reinforces and aggravates it. And so we can take a different approach. We'll be a lot better off. So thank you.
And now the same question to Justice Montoya-Lewis.
Thank you. The issues that were raised and addressed in that letter have been the driving force of my career. I have spent 30 years working to address systemic oppression, racial inequities, and other related things in our system. And I've experienced those in my day-to-day life, both professionally and personally. This letter that the court wrote was not just a letter, it wasn't just words. It was a commitment, and it was also a recognition of our own complicity as a court. And immediately following that letter, I did two things with the court's unanimous support. One was to reverse the Tawas-Newt case, which was a case that I read from the bench that reversed a conviction. And the other was to write a case involving the Indian Child Welfare Act. Both of those cases I'm happy to provide citations to that show the action and the commitment of this court and of my life in this role.
Thank you. The next one to Justice Montoya-Lewis. As a member of the bench, what role, if any, do you believe that a judge must take to provide equal access to justice?
I think that's one of the critical and most important roles that judges and justices have. And again, that has been part of my career in terms of access to justice. I believe that access to justice is not just related to racial equity and systemic oppression. It's also related to the physical access to the courthouse and to the ways in which we as a system and as judges invite participation in our system. There are all kinds of ways, big and small, that we tell people they are not welcome in our courthouses and participating in our system. And it is my view as a justice that one of my critical roles is to be a leader in this area in access to justice, in changing court rules that limit access, in educating the community, and in inviting participation in the court's decision-making as it applies to access.
Thank you, Justice. Judge Larson?
Thank you. That's an excellent question. That's been for 22 years. I've been trying to make the system, that's why I became a judge, to also wanted to become a judge, is to make the system more user-friendly. Access to justice just isn't about access to judges and lawyers. It's access to true justice. And our system is wired, especially in the area of family law and criminal law. It's kind of a meat grinder. And until we commit to in criminal cases, to make therapeutic approaches the upfront approach, especially with first-time offenders, and until we commit in family law cases to make it easier for people to navigate that system and help solve problems, we're going to be perceived as creating injustice rather than justice. Justice Montoya-Lewis, and again, I'm not criticizing her personally. It has to do with the decision to cut the limited licensed legal technician program that was available, that allowed filling out of paperwork for divorces to be done for the poor and the moderate means folks. We disagree on that. I think she has some good arguments against it and that program, and I believe that it should have stayed as far as an access to justice issue.
Thank you. Now a question for Justice Larson.
Judge Larson.
I'm sorry?
I didn't want you to call me Justice because I know.
Oh, Judge Larson, sorry. The Supreme Court not only issues decisions in individual cases, it also oversees the lower courts, approves state court rules, directs the work of commissions and committees such as the Gender and Justice Commission, the Minority and Justice Commission, and the Washington Pattern Jury Instructions Committee. What has prepared you to provide leadership for this work? If elected, in which area would you prefer to work?
Actually, it's everything I've done over the last 12 years as a judge and as a lawyer also. But again, I talked in my opening remarks. I believe there needs to be a behavioral health commission. I do believe that we need to form that because the court has taken leadership roles in areas of interest that need work, and this area needs work. One of the reasons I'm running is because we're down on the trial court struggling to deal with these issues, and although the justices are leading in other areas, there needs to be leadership in this area. It's killing communities. It's doing all kinds of things that are hurting us in our communities, and the Supreme Court's been silent on this. And we struggle. I work in the legislature, and we struggle trying to get things passed. The district and municipal court judges have a lobbyist. The Superior Court judges have a lobbyist. BJA, Board of Judicial Administration, has a lobbyist. We need to figure out how we can bring these things together so we can work together to solve this issue that's killing our community. Thanks.
Justice Montoya-Lewis.
Thank you. I serve as a member of the Minority and Justice Commission, and I serve on the advisory board for the Gender and Justice Commission, and I am also on the Rules Committee for the Washington State Supreme Court. So my experience in those areas, serving on those committees, prepare me to continue to do that work. As an expert in addressing systemic oppression, racial inequity, and best practices in domestic violence and child welfare cases, my work both on the Gender and Justice Committee as well as being a member of the Minority and Justice Committee allows me to bring together those areas of expertise to work on developing approaches to address the significant racial disproportionality that we have in our criminal system and our child welfare system, as well as our juvenile offender system. So I look forward to continuing that work as I've done over the course of my 25-year career as an attorney.
Thank you. Now, Justice Montoya-Lewis, please describe your judicial philosophy. The Constitution should be interpreted as a living document using the constructionist or originalist approach. Is legislative intent appropriate to consider?
Thank you. I think that it is important as a judge to recognize that what we are doing is applying the law to the situations that our society faces today. And as a result of that, I think it is critical that we interpret the Constitution, whether that's the federal Constitution or the state Constitution, based on what the Constitution requires us to do now. And so I think you used the words constructionist. I'm certainly not a constructionist. I am someone that believes that our constitutions are intended to be living documents that are to be interpreted to apply to society now. There are all sorts of questions that come up that certainly were never considered during the time of the writing of those documents that must be considered today. Legislative intent is equally something we should consider, but our first task on the court is to interpret the statute as it is in front of us and to base our decisions on the words we see on the page.
Thank you. Judge Larson.
Well, when we take the oath of office, we take the oath of office to support the Constitution of the state of Washington and of the United States. One of the problems we have is over time, because we haven't had an approach that really looked hard at the language of the Constitution, because you're not only supporting the words on the page, but the principles they represent. And just an example, Article 1, Section 1 of the state Constitution: all political power is inherent in the people. Government derives their just powers from the consent of the governed. Government's purpose is to protect and maintain individual rights. So because we've departed from that so far, we are in the situation we're in today because we aren't looking at the Constitution very, very steadfastly. We are loose on some of the principles. And as a result, it seems that we're in a mode, whether it's Black Lives Matters or whether it's the people protesting COVID, the common denominator is people versus the government and the government versus people. Because we're not truly, as government officials, applying the Constitution consistent with the way it was intended, which is to really be servants of the people and not masters of the people. So thank you.
Next question for Judge Larson. Keep trying to promote you. What areas of concern in the judicial system require new initiatives by the Supreme Court? And that's Judge Larson.
So I've already indicated the new initiatives. I mean, obviously the racial issues, the public trust and confidence in the judiciary on the race issue is a priority. And that, like I said, the letter needed to be sent. But again, some of the same things we could use in the area of addiction and mental illness, the therapeutic approach, for instance, first-time offenders, the first time somebody's in court, try to get the underlying issues then. If they're a person of color that's there that needs other things that can address some of the issues to where we can build them up instead of tear them down, where we start with that kind of approach, that initiative can tie in so well to a number of things in terms of trying to make the system, again, a repair shop for folks. The first time we focused on first-time offenders, just think how many lives we could save and how many communities we could better because we keep it from getting out of hand. And we're emphasizing too much. And we need therapeutic courts, but we use them when people are too much out of hand. We need to see it as a continuum where we are helping people from the beginning to the end. It's called the sequential intercept model. That has to be the new initiative. Thanks.
And Justice Montoya-Lewis.
When I accepted or was appointed to this position, I was asked what it meant for me to be the first Native person appointed to sit on the Washington State Supreme Court. And I understand that my appointment is a historic one. But more important to me than being a first is that I not be the last. Representation on this court, such that our court looks like the state it serves, should be the most important initiative that this court continues to move forward. Our court is the most diverse in the country as a state Supreme Court at this time. And many people look at that and say, we've made it. My view is that's the beginning, not the end. And so I believe as a court, we must commit to ensuring that the people that follow us continue to represent and look like the state of Washington.
Thank you. Neil, how much time do we have now? Well,
It's straight up 8 o'clock.
Is it? Okay. You can.
I'm sorry.
Chuck, you have time for another question.
Okay.
One last question there.
In the area of hate crimes, what are some of the issues of balancing free speech rights against the need to control offensive activity? And that would be Judge Montoya-Lewis, followed by Justice Montoya-Lewis, followed by Judge Larson.
I apologize. Could you repeat the question? It broke up there a bit. Could you repeat the question? I apologize.
Sure. In the area of hate crimes, what are some of the issues of balancing free speech rights against the need to control offensive activity?
Thank you. If you're ready for me to respond, I will.
Yes.
I do think this is a question that has the potential to come in front of the court, so I'm going to be a little bit careful about what I say. But in response to that, again, I've been a woman of color my whole life. I have experienced racism, both personal, systemic, and professional, for my entire life. I know what that feels like. This is not about offensive language or hurt feelings. This is an issue about some people's safety and whether or not someone's right to speak their mind, which is guaranteed by our Constitution, crosses over into violating someone else's safety. I frankly don't think that line is very difficult to draw. And as someone who has experienced both, I think as a justice, that experience matters in terms of interpreting what the law and the Constitution allows. And so I think that it is a complicated question, but I think in application, it's fairly simple.
And Judge Larson?
I agree with Justice Montoya-Lewis. I think, there's a provision in our Constitution that says a frequent recurrence to fundamental principles is essential to individual right and the perpetuity of free government. And what's so important is that justice comes from how we live. Justice comes from how we treat each other. We can make all kinds of laws and everything else, but we got to figure out how to be decent with each other, how to respect our differences, how to work with each other. And we've got to a point where I'm entitled to my opinion and you're entitled to my opinion too. And if you don't like it, you must be some, whatever. And this hate that's out there, we need to, as leaders, and regardless of who wins this, I implore us in the judiciary to be leaders of peace in our society, to be off the bench, out into our society, out into the communities, getting people to understand that not coming to court is more important. I always say we're the branch of government that constantly should be putting itself out of business. And we are, and one of the reasons I'm running is because I feel compelled. I feel like we're unraveling, and we need to get together to find ways to get along and to be peaceful with each other, because that's how we're free. So thank you.
Thank you. And we'll now go to the other two candidates for which is position 6, which is a 2-year unexpired term. And first, Justice Whitener.
Yeah.
What special qualifications and/or prior experience do you possess that makes you the best candidate for the office of Supreme Court Justice?
Thank you, and good evening to everyone, and thank you for having me. I was appointed in April. Prior to being appointed, I was a Pierce County Superior Court judge for 5 years. Prior to that, I was a Board of Industrial Insurance Appeals judge for over 2 years. I have been a prosecutor, I've been a public defender, I've been a private defense counsel as well. I also have the unique experience of having been a pro tem judge on the municipal court as well as the district court level. My experience is different than most in that I have been a prosecutor, I've been a defense attorney, and I've been a judicial officer on the municipal court, on the district court, as well as on the superior court, all 3 positions on all 3 levels. So I have an intimate understanding of our trial level courts. I'm also co-chair of the Washington State Minority and Justice Commission. I am a Supreme Court appointed judicial officer to the Office of Civil Legal Aid. Those 2 entities I hold near and dear. I lecture on a number of things, but most importantly, I lecture on access to justice in our courts as well as human rights. I'm also Washington State's 4th immigrant-born justice. I am the first Black female Supreme Court justice. I am Washington State's first and only LGBT judge, Black judge, and I'm an immigrant. I was born and raised on the island of Trinidad and Tobago, and I identify as having a disability. I have a back condition. So my background is as marginalized and as diverse as my professional background. What I bring to the Supreme Court is having handled thousands of cases over the years, to include complex civil, criminal, and family law matters, and those include trial court, jury trials as well. And I also have sat on oral arguments at the Supreme Court since joining the bench in April, and I've written 2 opinions. Thank you.
Thank you. Dr. Serns?
Good question. Good evening. Thank you for having us. Appreciate the opportunity. I think certainly if you look at my career path, one of my first challenges is to convince you of why I am qualified. I've said before repeatedly that I view running for public office as like applying for a job. So my job when I come for an interview before the hiring panel, which is the voters, is not to negatively contrast my experience with Justice Whitener. I respect her experience highly. She's very well qualified, and I think she is doing and will do a very good job. What I'm offering is to explain why I think I also have a skill set that is very valuable on the court, and one that I think is missing. On first blush, it's very audacious of me to file for this candidacy. I've spent my whole career as an educator, a school administrator. I would propose that you consider that in school law, there are many different, well, in school life in general, as an administrator, there are many different exposures to law and many laws that you have to become acquainted with and put into practice and be conscious of in all of your dealings with students, the community, and employees. I work for 2 different school districts, one Federal Way of about 23,000 students and Issaquah of about 20,000 students as an HR administrator. In that respect, you're responsible for many legal issues such as constitutional law, giving people due process, freedom of speech, freedom of expression. You need to know the parameters around that. I worked extensively in employment and labor law. We had something like 2,500 employees that I was responsible for managing. I was compliance officer for complaints regarding harassment and anti-bullying and so forth, and also a Title IX officer for gender equity issues. So there's a lot of exposure that one has in my experience that I hope to be able to explain in another question. I'll need to stop now.
Thank you, Dr. Serns. Let me now ask the second question. What do you consider to be the 3 most important attributes of a good judge? And that would be Dr. Serns, followed by Justice Whitener.
Well, continuing on the thought about experience, I think that there are skill sets that one develops that can be unconventional. The example I always use is John Stanford, who was hired to be the superintendent of schools in Seattle without any experience as a teacher or school administrator. So while I haven't had an experience representing clients and working as a judge, I have many experiences that I feel have given me the skill set necessary to be a justice in the Supreme Court. As was mentioned in some of the previous conversations you had with other candidates, I think the most important is being a good listener. After that, being able to ask probing questions and really understand where different points of view are coming from. And then to being a good investigator, a good researcher rather. I had over 20 hours of research in my graduate programs and as a PhD and law degree. And I'd have to go beyond 3 and say, then you need to deliberate, build consensus, and be a good writer.
Thank you. And next, Justice.
Well, thank you. I think that the 3 I would pick is first and foremost being able to empathize. And that is not sympathize, but empathize, being able to walk in the shoes of the individual that come before you in the courtroom so that you can understand the issue that they are raising. Then, of course, part of empathy is being able to listen and listen with understanding ears so that you can basically hear them, because many times we listen and we don't hear. what is being said. I would also say understanding the rule of law and the role of being a judicial officer. Understanding the law and being able to educate the individuals through your reasoning on their case about the law and how it works and how it applies to their respective case. And then, of course, most importantly, having a knowledge base in regards to the law so that you can apply it appropriately in regards to the issue raised and the facts that are brought before you.
Thank you. Next, the Washington Supreme Court recently issued a letter signed by all justices acknowledging that racism has infected proceedings and committing to address issues systematically. Are you familiar with the letter? What is your opinions of the letter? And how would that affect your actions on the bench? And that would be Justice Whitener.
Yes, thank you. Yes, I was present when the letter was issued by our court. I believe it was needed because our court gave directives to the lower court and to the legal community as to what is needed moving forward. And that is, we have a problem. We have a problem of systemic racism and structural racism in our courts, just like we have in other institutions. But the court is meant to represent all, and all need to feel that they have access to their courts. So the letter is addressing an issue that the court needs to address. The letter is giving directives to the lower court as to what is expected of them as judicial officers, and that is to uphold the law and make it applicable to all, irrespective of race, sexual orientation, gender, and the like. It is a court for all, and that is what the letter stands for.
Thank you. Next, as a member of the bench, what role, if any, do you believe that a judge must take to provide equal access to justice?
Mr. Rout,
And
I don't think you asked Dr. Serns that question that you asked me.
I'm sorry.
I didn't have the opportunity to respond to the last question.
Oh, I'm sorry.
So should I go ahead?
Dr. Serns.
Yes, I am familiar with the letter. I think it was well written and hopefully will be well received. I think perhaps the greatest problem in our whole criminal justice system is inequity. And I think one of the first things to address it is for us to all acknowledge it and better understand it. I was also pleased the Washington State Bar Association recently encouraged, if not required, that all attorneys have further training in the equity issues. I think as an educator, I feel that understanding and helping people understand the problems and explaining them is one of the first things in helping move the needle forward. I think most people hopefully intend to do the right thing, but a lot of times they don't even realize what is happening until they see the bigger picture. So I think it was well done and it's something I value.
Thank you. Next, for Dr. Serns, as a member of the bench, what role, if any, do you believe that a judge must take to provide equal access to justice?
Well, as I kind of alluded to earlier in the last question, one of the most important things for all of us is to have a better understanding of the problems that do exist. I think sometimes people aren't aware of them. So I am aware that there's a concern over a problem with access to justice, not only physically, but as some of the other candidates mentioned earlier, helping to educate people to better understand what justice is all about and how the legal system works. I commend Justice Whitener. She's shared in past meetings that we've been in where she does a street law course with with some students in high school. That's something I think is very valuable, and I think is one way that we can help educate the next generation. And we need to do that in all of our interactions and be the role model and the leader in what we do, in what we say, as well as what we do.
Thank you.
Thank you. And thank you for that, Dr. Serns. I live my life being a role model in regards to access to justice because of my marginalization. So when I joined the legal profession and then the judiciary, I continued. So I mentor from elementary school all the way up to judicial college. I lecture and do presentations in regards to the court and access to the court and what the court can do for the community. I go out into the community and do outreach, and I bring the community into the court so they can learn what their courts do. I also teach street law, as you found out. And I teach street law at Lincoln High School, and I've been doing that for over three and a half, probably 4 years. It's important that the community understand what it is we do as judicial officers, but it's also important as judicial officers that we understand what the community's needs are. So as a member of the Office of Civil Legal Aid and the co-chair of the Minority and Justice Commission, I participate in those activities to, as I indicated, to maintain contact with the community and what it needs.
Next question. The Supreme Court not only issues decisions in individual cases, it also oversees the lower courts, approves state court rules, directs the work of commissions and committees such as the Gender and Justice Commission, the Minority and Justice Commission, the Washington Pattern Jury Instructions Committee. What has prepared you to provide leadership for this work? And if elected, in which area would you prefer to work?
Well, if elected, I continue to work co-chairing the Minority and Justice Commission. It's one of the Supreme Court commissions and it's statewide. It deals with issues regarding race and ethnicity in regards to access in our courts. So we do programs such as pretrial services, jury service, bail reform, those sorts of things we handle. We try to move the agenda forward in that regard. As I indicated, I'm on the Office of Civil Legal Aid Oversight Committee. Most individuals that come to the court deal with civil issues, but they don't have a constitutional right to an attorney for those cases. So we have a lot of individuals who are maneuvering through the courts with no inkling as to what it takes. So those two commissions, I will continue to participate in as I've done before, and I will continue to teach and lecture and interact with young individuals so that I can prepare them and mentor them to move into these positions as they pursue their legal careers.
And Dr. Serns?
I'd like to start with something that Justice Whitener mentioned previously. I think in any type of problem solving and moving the needle forward, it's very important to include everybody, that everybody has a voice, everybody's impacted by the decision. So whether it's attorneys, whether it's clients, whether it's communities, judges, they all need input into the process and we need to listen. I think one of the skill sets that I've developed in my problem solving through the years, and I've had a lot of experience at, is facilitating problem solving and bringing people together and giving them voice. And I think that's one of the most important skill sets in regard to this question. In regard to the part that I would enjoy most, I think all of them are tremendously important. I've always been a champion of equity also, but my PhD was in policy development and analysis, and probably analyzing and writing rules would be an area that I would gravitate toward.
Thank you. Let me go to Dr. Serns now. Please describe your judicial philosophy. The Constitution should be interpreted as a living document using a constructionist or originalist approach. Is legislative intent appropriate to consider?
Well, first of all, I'll answer the second part of that first. I think legislative intent is important to consider. I'll use this opportunity to quickly say that I'm truly nonpartisan, even when I'm not running for a judicial position. I haven't considered myself either Democrat or Republican for many years, and I don't think I neatly fit into a box of conservative or liberal when it comes to this question of philosophy, of a judicial philosophy. I'm also somewhat, I view some elements of both are important. The strict constructionist model is, I think, the first lens that we should put on is see what the Constitution actually said and what the legislative intent is. However, as Justice Montoya-Lewis mentioned earlier, I think there are times where we need to consider the court as a living document as we move forward. An example I often use is that when the Constitution was written, we said all men were created equal, but only white male landowners could even vote. So certainly things regarding our understanding of what equal means and things like that do change with time and should.
And Justice Whitener?
Thank you. I don't like labels, so I'm always cautious when I'm asked for my judicial philosophy and which label you want to assign. I believe the Constitution is first and foremost the rule of law, and we need to apply it the best way we can. Having said that, you have to take into account the circumstances surrounding the application of the Constitution based on the issue brought before you. So therefore, it is a living document, and like every living and breathing thing, it depends on the issue, it depends on the facts that's being assessed, and it depends on the time that it is being applied. So I see the Constitution, especially as such a marginalized individual, as a breathing and living document that is accommodating as much as possible so that access to justice, which I see as just treatment, has true meaning.
Thank you. Let me now go to question number 7. What areas of concern in the judicial system require new initiatives by the Supreme Court? And Justice Whitener.
The new condition that we're all facing, which is COVID-19 and the impact it is having on our courts. We need reform, we need proper funding. As I indicated, I'm on the Oversight Committee for Office of Civil Legal Aid. Legal aid is needed to assist our constituents, our community members, in regards to the tsunami of cases that are going to be coming before the court that the individuals who are needing help don't have access to. Funding is needed for the court. That's the reform I'd like to see. We have landlord-tenant issues that have been backlogged that will need assistance. And some of it is coming in regards to some grants that have been given in the budget for the Office of Civil Legal Aid. But we also will have other legal issues in regards to jury trials, in regards to jurors, in regards to making sure everyone is safe, and then utilizing technology moving forward. We need to create the infrastructure for these things that have been brought on by COVID.
Thank you. And finally, in the area of hate crimes, what are some of the issues?
It's kept my response again. Okay, I would like to answer that by saying I think we need to continually have new ways of looking and new ways of addressing new initiatives to try to solve the biggest problem that we have is the inequity issue. There are inequities in our criminal justice system because of race, because of income. Sometimes people are showing preference because of their partisan affiliation, their special interest group they belong to, maybe being that they're a public figure and more well-known. I don't have the answers on how all those things can be resolved, but I think we need to acknowledge them and we need to continually work on them, and probably again through ongoing education and training for attorneys and for constituents and judges and everyone.
And finally, the last question. In the area of hate crimes, what are some of the issues of balancing free speech rights against the need to control offensive activity? And that would be Dr. Serns.
I think I would agree with the comments that were made in the previous discussion that it is obviously it's a tension between two important concepts, freedom of speech and protection of people. We have a lot of precedent throughout our history of there's certain free speech there's certain types of speech that is not allowed and not free because it endangers other people. So when speech crosses the line and endangers other people, there needs to be consequences for that. So I think we have some laws in place for that already. As was mentioned, some of those nuances might come before the court, and probably shouldn't say too much about exactly what that should look like, but those are the two issues: protecting people's freedom of speech and also protecting people's safety.
Justice Whitener.
Thank you. Hate speech is not protected speech. However, offensive speech may be. Having said that, as a marginalized individual, I have faced hate speech. I have been called the N-word after putting on a program in Pierce County to empower and inspire young girls to the judiciary and the legal profession. It garnered widespread accolades, and it is now being offered 3 times throughout the state at different places. It was offered in Yakima, Spokane, Thurston County, and Whatcom County. But with that came hate speech, where I was called the N judge, trying to empower and inspire the N-type children. That speech is not protected. If someone says they did not like the program, that would be fine. That's offensive, or it could be offensive. But hate speech is not protected speech by our Constitution. Offensive speech may be.
Thank you. And that concludes the questions. I appreciate your excellent answers, and good luck to all of you.
Thank you so much for having me. I appreciate it. And good night, Dr. Serns.
Thanks. Good to see you again.
Good to see
Thank you very much.
I'd like to add my thanks to the state Supreme Court candidates for your participation in our forum this evening. It's a busy time for you with less than a month to go to the election. So in campaign time, all that time, every minute's valuable to you. So we do appreciate it. Your comments and your responses were very helpful to us in getting a better understanding of the work of the court does. And so thank you for that. Well, thanks too to Chuck Ruth for a good job as moderator of this evening's discussion with the Supreme Court candidates. Thank you all.
Thank you. Good night.
Sure.
Now we'll move to the second part of our tonight's forum, when we focus on 2 of the 16 issues that will be on the November ballot. As I mentioned in my opening remarks this evening, the Election Forums Committee has prepared a written summary of all the ballot issues, which we distribute to residents a week ago. And we're presenting 4 of the ballot issues orally, 2 last Monday and 2 this evening. First this evening will be the King County's $1.7 billion bond issue for health and safety improvements at Harborview Medical Center. And the second one will be a City of Seattle proposal for a transit tax increase. The presentations this evening will be by 2 residents who are members of the Election Forum Committee. This is the first of the ballot issues. Would be the Harborview bond issue, and the presenter will be Carol Madigan. Carol.
Okay. Hello, and thank you for having me. Before I start my talk about it, I would like to thank Sue Vandam for helping me put this together. She did a lot of work on it, and she should get some credit. Do you want me just to start with my talk now?
Yes.
Okay. The Metropolitan King County Council passed ordinance
Carol, unmute yourself. Yeah.
Okay.
Yes.
All right. I'm sorry. The first thing I want to do is thank Sue Badman for her help with putting this together. To begin with the proposition, the Metropolitan King County Council passed an ordinance number 13896 concerning the proposition to issue Harborview Medical Center improvement bonds. That proposition would authorize Harborview to make seismic, health, and public safety improvements to the hospital, including demolition of unsound buildings, construction of new buildings, and both renovation and upgrading of existing facilities through the general. It would be paid for through the general obligation bonds of $174 billion to be paid back in 20 years. It would come from property taxes that would cost a homeowner about $75 for a $600,000 house. King County Executive Dow Constantine sent legislation to the council to pass this $174 billion bond, which they did unanimously. The bond is meant to protect and save King County residents from the next disaster, pandemic, or epidemic. Harborview is a 413-bed hospital, and it's owned by King County. It is a home to a range of critical medical behavioral health services. Per year, 70,000 patients are seen there. 14,000 are hospitalized. Right now, because of safety protocols due to the pandemic, 50 beds are unavailable for the emergency room. And these 50 extra patients are put into ICU room beds or post-surgical beds. These are much more expensive per day than emergency room beds. Harborview combines state-of-the-art emergency medical services, including excellence in burn, neurosciences, ophthalmology, infectious diseases, and rehab therapy. It is one of the nation's leading academic medical centers and the only level 1 trauma center serving the states of Washington, Alaska, Montana, and Idaho. This bond would expand behavioral health services, which I think was well addressed with the lawyers before us. It would be in a new facility building, including ongoing homelessness and mental health crises. This investment is meant not only to fund the already vulnerable population, but also to help individuals receive treatment to prevent crises from occurring. Right now, the current helipad is not connected to the emergency room. When a patient is flown into the helipad, he has to be transferred to an ambulance, taken down to the street level and around to the emergency room. This would be resolved in the new building they are planning. The work permitted by this board should create over 7,700 family wage paying jobs during the construction and thousands of caregiving positions in a safe, modern environment tailored to patient care. And to date, there has been no formal opposition to the bond issue, despite its very large cost. I'm done.
Thank you, Carol.
I bet.
Thank you, Carol. The second valuation will be on the city of Seattle.
Yes, I hope I'm sufficiently engaged here.
Bobby Spaeth. Thank you, Bobby.
Thank you. This November, can't see myself, but that's okay. Okay, so this November, Seattle voters will be deciding what's probably the most unexciting measure on our ballot, the renewal of an existing tax, more or less. Its purpose is to support public bus service within our city limits, and how we got there is complicated. Can't control it. There we go. Okay. Nope, can't control it. I don't have access. Okay, well, let's do this without it then, because I cannot advance the slides from my computer. Okay. Okay, so how we got here. In the 19th century, private companies ran transit in Seattle. And in the first decades of the 20th century, they sold some of the equipment to the, that was magic. Neil, can we exit this? Because I can't run the screen. I'd like to get back. Can I just have my screen back?
Yeah, you should be. There you go.
No, I'm not there. I have video, but I can't see myself.
We can see you.
Wonderful. I can't see you. All right. Anyway, it's complicated. And once upon a time, there was a struggle in Seattle about who was going to run the transit system. And it turned out to be the city. And buses then went on to replace the streetcars. Well, during World War II, the bus ridership soared, but post-war, auto ownership boomed and ridership on the buses dropped, and federally funded freeways were built to serve the growing suburbs. Regional leaders tried to create regional transit, but the voters were never persuaded in those days, and the Seattle bus fleet was becoming dilapidated. There were a few private bus companies running some sketchy service in King County, and the regional rapid rail bond issue was rejected by the public at the polls in 1968. Well, transit advocates gave up on rail, and in 1972, the voters finally approved a ballot measure that added funding for a bus system to the sewer utility for the county called Metro, having carefully left out King County's rural areas and their anti-transit voters. Grumbling over Metro's indirectly elected governing body brought the legal challenge in 1990. It was ruled to be unconstitutional. So in 1993, Metro's bus and sewer management and its funding was merged into King County's government with an enlarged council. Now, fast forward to today, and Seattle voters are being asked to fund King County's Metro bus service with additional funding that operates buses within the city limits. Seattle Transportation Benefit District Tax, or Proposition 1, on our city ballot would replace a 6-year-long tax of 1% on sales and use and a $60 per year vehicle fee. The new proposal responds to the fact that the local vehicle fees were under legal challenge from statewide forces that were led by Tim Eyman, and backers of Proposition 1 and the city's elected leaders had acknowledged that the sales tax would burden the poor. But they say they will replace this sales tax with a tax on developers if the car tab repeal challenge is successful in court. Now, like its predecessor, this transit measure would expire after 6 years in 2027. It would raise less than the current levy, $42 million a year, funding additional bus service, transit passes for students and people with low incomes, and emergency needs, such as addressing the effects of the current pandemic and the closure of the West Seattle Bridge. The current tax raised $56 million last year, and precise allocation of the funds is to be determined. Now, oversight is assigned to a special 12-member board composed of citizens with interests or workplace involvement with public transportation. The mayor appoints 6 members of the oversight board, the council 5, and the 12th member is designated as the representative of a group called Get Engaged. Brian Stromer is that person, and his term expired August 31st. The Transit Advisory Oversight Board shows that the majority of the terms of its members, 7, have expired. Now, there's no announced opposition to the measure, More than half of the funds raised annually will go for more service on the metro routes that serve 65% or more of their stops in the city, as well as the metro rapid ride lines that are in Seattle. Now, the city must issue an annual report on how the Proposition 1 revenues are used and the impacts of King County's service reductions, increases, or changes inside Seattle city limit. Now, to sum up, because this is about money adding up, the city elected seek extra funding for city bus service because Seattle has extra public transit demands that are different from the suburbs. And now it faced more costs related to the pandemic and the West Seattle bridge closure. This revenue comes on top of the tax the city voters pay that supports the 3-county regional transit authority funding Sound Transit, light rail, commuter rail, and regional bus. So if approved, the city's taxpayers will not only pay their King County transit tax and their RTA transit tax, but also this special Seattle Transportation Benefit District sales tax, Proposition 1.
Oh, okay. Thank you, Bobby. Nice job. So,
stop video. Okay.
As we conclude our election forum series for 2020 this evening, let me thank our residents for their patience and understanding for what we've tried to accomplish this year. We attempted an ambitious schedule for 6 forums with candidates for 8 statewide offices, and we conducted them virtually rather than in Anderson Hall, where we've done the forums for years. We had a lot to learn, and we hope it was successful and educational experience for you. I'd like to thank the terrific election forums committee that we had this year. I'm not going to list all 23 committee members, but I'd like to single out several people behind the scenes who played a key role. Doris Ray, who headed a subcommittee that met weekly to do the research and develop the excellent questions for the candidates that we've used in each of the forums. May Gerstel, who was the lead in promoting the forums and in preparing the information materials for you prior to each forum. Peter Shapiro, for playing a especially important role in this year of the virtual forum. Peter and his technical team not only had to produce each forum, but he had to train the rest of us on how to use Zoom. No small task. Our timer tonight for the other 5 forums this year was Adele Reynolds, who played an important role in that respect and also in several other ways during the course of the year. And thanks to 2 of Peter's key players on the technical team, Rita Ransom and Bryant Levitt, and to the Horizon House management for their support that we've had. So normally I would like to ask you to give these folks a round of applause. With the COVID-19 restrictions, let me suggest that you thank them personally when you see them in the halls. To all of you in the audience, thanks for joining us this evening and for your support during this 2020 election seasons. Ballots will be mailed Wednesday, so be sure to cast your vote in this very important November general election. Good night.